Welcome to Motivation at Hand, Ma. To know is to know how. Part 6. Case 123 CR 00257 TSC Document 139 filed November 6, 2023, in the United States District Court for the District of Columbia, United States of America versus Donald J. Trump, defendant. Government's omnibus opposition to defendant's motions to dismiss the indictment on statutory and constitutional grounds. A. The defendant's statutory challenges lack merit. 2. The indictment adequately alleges violations of 18 U.S.C. sections 1512K and C2. B. The indictment alleges the defendant acted corruptly. The defendants claim that the indictment fails to allege that he acted corruptly. Electronic case filing, ECF number 114 at 24-27. Is patently incorrect. The indictment charges that the defendant conspired to corruptly obstruct and impede, ECF number 1 at paragraph 126, and that he attempted to, and did, corruptly obstruct and impede, the certification proceeding, same as paragraph 128. Criminal intent alleging a violation of section 1512C, 2's mens rea, criminal intent, element by. Tracking the statutory language disposes of the defendant's claim that the indictment failed to allege that he acted with corrupt intent. See United States v. Williamson, 903 F. 3rd 124, 130, D.C. circa 2018. The defendant's additional challenges to the corruptly element are both premature and flawed. The defendant discusses the D.C. Circuit's recent decision in Robertson at length. But that decision reviewed the evidence after a trial and concluded that ample evidence established the defendant acted corruptly. 2023 WL 6932346, at 9, the evidence presented at Robertson's trial was undoubtedly sufficient to prove that he acted corruptly. Robertson does not alter the long-standing rule that, in order to inform the defendant of the nature of the accusation as required under Rule 7 of the Federal Rules of Criminal Procedure, see Estes, 795 F. 3rd at 148-49. Parroting the language of a federal criminal statute is often sufficient, Williamson, 903 F. 3rd at 130, quoting United States v. Resendiz-Ponce, 549 U.S. 102, 109, 2007. Compare United States v. Brock, 628 F. 3rd 85, 93, DDC 2022. Noting that a defendant is not entitled through an indictment or a bill of particulars to a preview of the government's evidence or theory of the case. Thus, while relevant to jury instructions, Robertson's interpretation of corruptly is not relevant to the defendant's dismissal motion. Moreover, Robertson demonstrates that there are multiple ways to prove that the defendant acted corruptly. 2023 WL 6932346, at 8. The alternatives include using independently unlawful, felonious means, same as at 9, and acting with a corrupt purpose, same as at 11. Which includes acting with an intent to procure an unlawful benefit, Fisher, 64 F. 4th at 352, Walker, J., concurring. Such as securing the presidency, same as at 356 number 5, and acting dishonestly, Arthur Anderson LLP vs. United States, 544 U.S. 696, 70607, 2005, C. Robertson, 2023 WL 6932346, at 12. Noting that dishonesty or seeking a benefit for oneself or another is not necessary but may be sufficient to prove corrupt intent. The proof at trial will establish corrupt intent under the definitions in Robertson. Contrary to the defendant's speculation about prosecutions that might reach political advocacy and lobbying, ECF number 114 at 26-27. Proceeding on a corrupt means or corrupt purpose theory will ensure that, section 1512C, 2, does not penalize innocent efforts to obstruct an official proceeding, including by engaging in constitutionally protected expression. Robertson, 2023 WL 6932346, at 17. 3. The indictment adequately alleges a violation of 18 U.S.C. section 241. Count 4 of the indictment charges a conspiracy to deprive one or more persons of their right to vote and to have their votes counted, in violation of 18 U.S.C. Section 241. As relevant here, the defendant advances two claims. First, he claims that the indictment does not allege an agreement to commit an unlawful act. Second, he argues that the indictment fails to charge the necessary specific intent. Each argument fails. Footnote 8, the defendant's fair notice challenge to Section 241 is addressed. Compare pages 37 to 40. A. The indictment alleges a criminal agreement. The defendant first contends, ECF number 114 at 28, that the indictment contains no agreement to commit an unlawful act. That claim is flatly contradicted by the indictment, which alleges in count 4 a conspiracy to violate the rights and privileges secured by the Constitution and laws of the United States of one or more persons, that is, the right to vote and to have one's vote counted. ECF number 1 at paragraph 130. The count incorporates dozens of factual allegations laying out how the defendant and his co-conspirators carried out their criminal agreement, including that they pursued unlawful means of discounting legitimate votes and subverting the election results. Same as paragraphs 4, 129. The indictment is more than sufficient to inform the defendant of the nature of the charge. Footnote 9. The defendant's suggestion, ECF number 114 at 28, that a violation of Section 241 requires proof of an overt act is incorrect. See United States v. Whitney, 229 F. 3rd 1296, 1301 10th Circuit 2000. B. The indictment alleges the requisite mens rea, guilty mind. The defendant next claims, ECF number 114 at 32, that count 4 fails to allege that the defendant acted with specific intent and acted to accomplish a governmental purpose. He relies exclusively on a 50-year-old case from the Fifth Circuit, Wilkins v. United States, 376 F. 2nd 552, 562, 5th Circa 1967. But fails to recognize that a subsequent Fifth Circuit case, United States v. Purvis, 580 F. 2nd 853, 856, 5th Circa 1978, clarified Wilkins and directly contradicts his argument. While the government must prove at trial that the defendant had the specific intent to deprive one or more persons of a constitutional right, there is no requirement that the indictment contain these particular words. See Purvis, 580 F. 2nd at 857. The law does not compel a ritual of words. It is sufficient if the indictment tracks the statutory language and identifies the constitutional right at issue, same as at 857 to 88. As the allegation of a conspiracy itself incorporates willfulness and specific intent, same as at 859. Here, the indictment tracks the language of the statute and provides a detailed factual predicate for the charge. See same as at 857. Additionally, the indictment directly identifies the rights at issue, the right to vote or to have one's vote counted. Rights the defendant has conceded are fundamental. ECF number 114 at 29. That is more than sufficient for purposes of pleading a violation of Section 241. Further, relying on United States v. Ehrlichman, 546 F. 2nd 910, D.C. circa 1976, the defendant contends that the government must prove that the defendant acted to accomplish a governmental purpose. ECF number 114 at 32. Putting aside that he is again raising a trial issue, the defendant's reliance on Ehrlichman is misplaced. Ehrlichman does not rest on a distinction between government and private purposes of the conspirators, as the defendant suggests. The defendant in that case was convicted under Section 241 of conspiring to break into a psychiatrist's office. 546 F. 2nd at 914. The right infringed by the conspiracy was the psychiatrist's Fourth Amendment rights, same as at 928, Leventhal, J., concurring. And the passage the defendant focuses on stands for the unremarkable proposition that the Fourth Amendment protects only against unreasonable searches and seizures undertaken by the government. Same as, it is a civil rights conspiracy in violation of Section 241 if they enter his office in their capacity as government agents without proper authorization to secure information for an ostensible government purpose. See also United States v. Jacobson, 466 U.S. 109, 113, 1984. This court has also consistently construed this, Fourth Amendment, protection as proscribing only governmental action. However, because the right to vote in a presidential election is directly protected under the Constitution, see Bush v. Gore, 531 U.S. 98, 104, 2000, per curiam, by the court, see also compare pages 38 to 40. A Section 241 charge of conspiring to interfere in the free exercise of that right requires no proof of government involvement. See United States v. Classic, 313 U.S. 299, 321, 1941. The right to vote in a congressional election is a right secured by the Constitution, and that a conspiracy to prevent the citizen from voting or to prevent the official count of his ballot when cast is a conspiracy to injure and oppress the citizen in the free exercise of a right secured by the Constitution within the meaning of Section 241's predecessor. Count 4 is therefore sufficiently pleaded. Footnote 10. Even if the right alleged to have been infringed is viewed as a violation of the equal protection and due process clauses, the defendant, as president, was indisputably at times a government actor, even if he was also acting at times in his capacity as a candidate. See Classic, 313 U.S. at 326. Misuse of power, possessed by virtue of state law and made possible only because the wrongdoer is clothed with the authority of state law, is action taken under color of state law. Moreover, it is well established that when the object of a Section 241 conspiracy is to violate a right that protects against action by the government, whether it is the Fourth Amendment or the Equal Protection Clause of the 14th Amendment, not all co-conspirators need be government actors. United States v. Ollinger, 759 F. 2nd 1293, 1304, 7th Circa 1985. Nor is it essential that the state official be a party defendant. It is sufficient if the proof involves a charge of active connivance by agents of the state in the wrongful acts done in furtherance of the conspiracy that will meet the test of state action, as required under the rule enunciated in United States v. Guest, 383 U.S. 745, 1966. In Guest, the court denied defendant's motion to dismiss a Section 241 indictment, alleging an equal protection violation, finding that because the indictment alleged state involvement, how the government would prove the violation was a matter for trial. 383 U.S. at 756. The same analysis applies here. To be continued. Part 7. B. The defendant's constitutional challenges lack merit. Much appreciation to you for giving of your time with us at Motivation at Hand. To know is to know how. We trust you will come back soon.